Well, good morning, everyone. Welcome to hearing number 22 for the residential zone of the proposed Selwyn District Plan. Just a brief introductions from us in case some of you haven't been here before. My name's Rob Van Voorthausen. I'm an independent hearings commissioner based in Napier.
I'm Raven Solomon. Kia ora, I'm Raven Solomon. I'm an independent commissioner.
Kia ora, Lindsay Daish. I'm an independent commissioner based in Wellington.
Kia ora, I'm Malcolm Lau, Selwyn District Councillor Commissioner.
Great. And if the officers could just introduce themselves to the hearing.
Good morning, I'm Jocelyn Lewis, the Section 42A writer for the residential chapter.
And good morning, I'm Justine Ashley, a planner assisting the council.
Great. And just before we hear from our first submitter this morning from the officers, anything for us before we do that?
No, sir.
Thank you. So the first submitter on our list is Mr. Jason Hardy. Come on up, and you can choose where you want to sit. Just push there's a button on the right hand side. If you push that, a red light should come on. Yeah, that's great. All right, now, Mr. Hardy, good morning and welcome, and to yourself and other submitters who may be watching the live stream and are going to come in later. Thank you very much for making the initial submissions and providing any written material that you have thereafter. Anything that's been pre-circulated, we've already read, so you don't need to read that out loud to us.
Okay.
You are very welcome, though, to summarise key points from anything that you've already written, or just to tell us in your own words the key points that you want us to bear in mind going forward. So with that, over to you.
Yep. Okay. Well, hello, my name's Jason Hardy. I work as a roof cleaner. Sort of out of my comfort zone here, so just bear with me a bit. I live at a residence in Landor Common and have done for the last 22 years. I'm an avid campaigner against commercial activities in the Markham Way, Wilbur Close, Landor Common and Peel Close area. I've been asked by concerned residents in that area to speak on their behalf. I hope to do them justice. This all started in 18th of December 2018 when we received a letter in the mail asking us for our thoughts on putting an overlay on the Living One zone to allow commercial activities. We contacted the residents and did a petition. At the time, 62 signatures. This was handed to David Ward and Jessica, I hope I got this right, Tualipa, who called a meeting on the 4th of April 2019. This meeting filled the whole CAF at the old the cafeteria in the old part of the building. Mr. Lyle was there with affected residents, and I think the council members, they were surprised at how many turned up. And it was in the evening too, so it was a lot easier for residents to turn up. It was 6 till 7:30 or something like that. I can't remember the time. Yeah, but basically we were told by Sam Brighton at the end of the meeting this overlay would go ahead, and there was nothing we could do about it. The meeting got very heated at the end. Before the end, he said we would have a chance to have our say in the proposal of the Selwyn District after that few residents gathered on Markham Way. Most were of the opinion the council had already made up their minds and fighting it would be futile. Then the district plan came out. After several emails, Sam and Jessica finally understood the rule. It was a small section, easily missed. Myself and 3 other residents had a meeting with Sam, and once we knew how to submit and put it together, we contacted the residents on our Facebook page, wrote up a generic submission, which Sam said would be okay. He said an individual submission, whether it be generic or individual, is better than nothing. Some people find it hard to do this sort of thing, and this is understandable. When we were told it was happening anyway, so that was one sentence, so they understand. Sort of got that wrong, but anyway. So out of the 493 submitters that submitted on the Selwyn District Plan, 74 submissions were opposed to the rule GRZR15 commercial activities. A substantial amount of submitters on one proposal, more than on any other. One from the Rolleston Residents Association, neither supporting or opposing. with some good points, and 2 supporting in part, talking about a different rule. GRZR 15.4 refers to properties outside the PREC3. So they are commenting on the same rule, but it applies to other properties in the GRZ. Their submissions do not specifically relate to the Markham Way area, but if they remove the PREC3, this rule could cover Markham Way area. In relation to commercial activities, these 2 same developers are the same company but different names. One that supported it, no explanation was given, and that was from Housing New Zealand. I did a further submission to these 3 with no reply. In the KAC report, it said it would be left up to the residents to decide their fate. And by the number of submissions, I think the residents have had their say and reject rule GRZR 15. This has caused a lot of stress and anxiety for me and the submitters. I know you have read the submissions, so I know you understand what people are going through and the reasons the submitters oppose this rule. Just a few things. The frightening thing is that the Tennessee Street had a transitional precinct overlay, and you got to look what happened there. They took the houses away and put up tilt slabs. Even in rule GRZ 15, R15, it says for small business use only. But if they apply for a resource consent, they can do anything they want. So this overlay, the community activities overlay, is just a stepping stone to getting rid of those properties. They've already had in the last 3 months, 2 houses have been removed from Markham Way, living 1 zone for commercial activities. The residents of Markham Way, Wilbur Close, Peel Close, oppose rule GRZR 15 commercial activities, and we appeal to you, the commissioners, to reject this rule so we can live our lives as we are accustomed to without the commercial activities next door. I think that's basically about it. Just about, you know, I think we read in the submissions about parking, congestion, traffic, noise, loss of property value, resource consent. You know, they can really do anything they want here. So slowly we'll get pushed out. Yeah. Right. Any questions? I don't know, but when I said I've got support from the residents, I've actually got everyone signed a piece of paper. Did you get that? Did you?
Yeah, we did get that. And
was that this morning, was it?
Yesterday, I think we got it.
Oh, you got it yesterday?
Yeah, and there was a picture of a tilt slab wall. What street was that on?
That is at the end of Peel Close, and that's what's happened, and that's what we don't want happening to us.
Right.
That is like that. You can only walk down just in between that wall and that fence. That's a residence there, and if you say that's increased the value of their house, well, I don't think it has. But you know, I wouldn't want to be living next door to that.
Yeah.
Yeah, I feel, you know, she would, when I spoke to her, she was very upset. And the conflict that I've had with the developer over that, and I didn't think you were allowed to do that, but obviously, you know, you can. So yeah, not a very good thing to have. I feel sorry for them too.
Yeah,
they don't want to move, but they've got that to look at now. You know, they won't get any winter sun or anything like that there.
so just before I hand over to questions from the panels, just to clarify, so at the end of Peel Close, so the tilt slab wall, does the front of that tilt slab wall building front Tennyson Street, does it? Is that how that works?
Yes, yeah, that's the back of the building from Tennessee. It's quite a lot, must be about 40 metres or something in there.
Okay.
And it's right up against the fence line. They're a back section, and it's from one end of their section to the other.
Yeah. Okay. All right, I'll just see if we have any questions for you, Lindsay.
Thank you, Mr. Hardy. You said that you first heard about a proposal to actually have a precinct over this property back in 2018.
Well, that's when we got our letter in the mail asking us for our thoughts, and that's when we did that petition where we got 62 signatures. I think that there had been a lot of different plans, you know, they in that area over periods of time. You know, there might have been something else before that. I can't quite remember. But they were going to put roads through. They were going to take out a couple of houses down Langdor Common and put a road that went through there. So there has been a lot of other plans and stuff like that. But really, I think officially that was probably the first time we'd heard about. I'd ever heard about a transitional precinct overlay. I think that's what it is. Yeah.
And the reason why the council proposed the precinct is that it's actually surrounded on three sides. This block of residential is surrounded on three sides by TCZ. So just to clarify, your relief or what you want out of this is to remove the precinct overlay.
Well, what is that? The PREC3?
Yeah.
So what I don't really understand that. What the proposal was from the council was to put an overlay over that to allow commercial activities. What is the PREC3 exactly?
Okay, it is a precinct over the general residential zone, which has a different planning regime to the rest of the general residential zone.
Yeah.
In that, and one of the things is that there is a specific rule which allows, which is the rule you referred to, as a permitted activity, relatively small scale commercial activities to establish as a right, subject to various conditions. So that's my understanding of the.
Yeah, not quite. Yeah, yeah. My understanding was that it's a living one zone, and this rule GRZR 15 is so they can, the proposed rule they want to put over that now in the Selwyn district plan is for so they can have commercial activities. Yeah.
Yes. Well, that's my understanding of what the precinct does. It differentiates this block of land from the remainder of what we now call general residential. The living one is the current district plan zone.
Yeah, because that's going to change to GRZ, isn't it?
Yeah,
right?
yeah. So it's GRZ, and then there's another process to go through next year in terms of yeah. So we needn't worry.
Oh, is there another process? Is there? Oh, you let the cat out of the bag there. So what is the plan?
Well, what we have in front of us at the moment is a proposal.
Yeah.
In the proposed district plan to have a precinct overlay over this land, which differentiates it. And the differentiation it is that it does provide as of right, subject to a whole lot of conditions, commercial activities to establish on this land.
Yeah, well, that's what we're trying to stop.
Yes,
the commercial activities.
I think your position is very clear. I just wanted to clarify with you that there was a general understanding of what this proposal is.
Yeah, I'm just a resident there. I'm not a not up to speed on all that. Yeah.
Yeah. Well, okay. Thank you. I have no further questions.
Raymond, any questions?
No.
And Malcolm?
Yeah.
And Mr. Hardy, I don't have any questions for you. The only reason is that what you're wanting us to do is very clear, so I don't need to clarify from you what you want us to do.
Yeah.
So thanks very much for making the submission and
just one other thing too is we just want to be left alone, really. A lot of people find this very stressful. As you can see by that forms I gave this morning. We only signatures have 63 or something like that on it. Yeah, and I think it was about 45 residents. There was a few people I couldn't contact, not for not trying, but and there was about four rental properties in there, which we didn't get them to sign. We didn't know who the owners were. Yeah, but it is very stressful for us. We haven't done anything on our house because we don't know what's happening in the area. You know, my wife wants to do you know, decks and all that sort of thing, but I can't see the point until we find out what's going on in the area. Yeah. Okay, right.
I understand.
Yeah. Okay, thank you.
Thank you. Retirement Villages Association, come on up. So, Mr. Collins and Mr. Turner,
Yes, good morning.
good morning and
Commissioners.
welcome.
I'm John Collins. I'm the Executive Director of the Retirement Villages Association. Richard Turner is the Director of Mitchell Daesh,
Yes.
who we use for consulting obviously a lot. You've got our submission.
Yes, we've had the submission and the evidence that you each provided, so thank you very much for doing that. And just to repeat what I said earlier, we've read the pre-circulated evidence, so you don't need to read that out loud to us. But of course, you're very welcome to summarise it or highlight key points for us.
Thank you for that. We really don't want to sort of take up too much of the Commissioner's time, but it is an important aspect for the retirement villages industry as a whole to make sure we have as far as possible, a level of consistency in planning regulations across New Zealand. We made a number of submissions to Tier 1 councils and also to government on various pieces of legislation that they've got there. Basically, the industry sees itself as providing a mainstream option for housing older people. Villages are designed for older people in mind. People downsize from often a 250 square metre home to a village to a unit of village, which might be somewhere between 80 and 120 square metres. But of course, the range of amenities which go with that, with the village, compensate in some extent for the fact that they've downsized to a smaller unit. And in so doing, they then move from an older home, which may be less suitable for someone in their 70s and 80s, to a village which is purpose-built and designed for older people. It has access to community amenities. Residents come from within a 10 or 15 kilometre radius of the village, so they want to stay in their own home area. I mean, make use of the same clubs, churches, medical facilities, all those sorts of things they've enjoyed in the past. From our perspective, it's important that villages do have a differentiation, if you like, from standard conventional residential developments. We are much more land use intensive, generally speaking. We have a wider range of activities and facilities for residents. We are offering a new styles of housing for older people, and in so doing release large numbers. We estimate 5,500 family homes back into the community each year. So the purpose of coming today is really to sort of explain what we are, answer questions about a submission. Richard, you have some points about the planning specifics for the district.
Mr. Collins, is it all right if we ask questions of you first before we hear from Mr. Turner? Yeah,
Absolutely.
Yeah.
If I don't answer, I don't know.
That's
I'll
all
refer
right.
to Richard.
And just for your information, Commissioner Daesh and I, we're both familiar with retirement villages in terms of being decision makers on applications for retirement villages. In my case, in the North Island, both under run-of-the-mill Resource Management Act processes and also under the COVID-19 fast track legislation. So
Excellent.
we've done a number of those jobs, so we're very familiar with retirement villages and their needs and the consenting processes. So just to give, if that gives you any comfort, I thought you might want to know that.
Well, thank you for that.
Now, see if we have questions for you, Lindsay.
No, I don't have any specific questions of you, Mr. Collins. Thank you.
Raymond?
Yes, I do. First of all, thank you, Mr. Collins. I found your submission really helpful. It answered a number of key questions that I had when I read the marked up version. But I just have one question.
Absolutely.
At paragraph 44, you talk about 124 residents between 6 retirement villages.
Yes.
What would the average carrying capacity, current capacity be of those 6 retirement villages?
In terms of units already established, or when you say carrying capacity, what?
How many residents can they accommodate?
Oh, right. Okay. Well, currently we've got around about 111 units, and based on a ratio of 1.3 residents per unit, that's be about 140 residents now. We're looking at 531 units in development,
Yes.
which when that's completed, which obviously is going to take a number of years to get through, we'll be looking at an additional 690 residents, which is a sizable percentage of the over 75 population in the district.
Great, thank you.
Malcolm?
Yes, interested. We made a comment there just previously about the differentiation where the retirement villages are, in your words, land use intensive. I'm just interested in what is the plan is talking about residential character, and I'm interested because if it's land use intensive and it's more of a gated community, I'm just interested in how they marry together with having a large gated community, and obviously you would like to see easier to establish such communities. And I'm just wondering how we preserve the character of the communities that we already have when we put these large intensive areas within them.
Yes, absolutely. When we talk about the intensification, it's actually probably thinking more of vertical developments rather than horizontal. Often a horizontal development will resemble the community that it's part of, but it will be the houses will often be much closer together. The roads are a little narrower. There'll be a community facility which itself will often contain the swimming pool and the gymnasium, the library and the cafe and cinema and all the rest of it. Occasionally that might be 2 stories or 3 stories if they want to build a medical an aged care facility as part of the village, which is the usual approach these days. Our residents are looking for a continuum of care from independent living right the way through to hospital or dementia level care. So it's important that we offer that continuum of care. So when I talk about land intensification, that's probably in a horizontal feeling. That's really where I mean. As far as gated communities are concerned, we try and avoid it's a bit of a balance between providing security for residents, because that's one of the principal reasons why people move to villages, for the sense of security, but actually making sure the village is actually open to the community in which it's part of. So there's more of a two-way flow. So residents obviously go out and are part of that community. We encourage operators to bring the public into the village to make use of the amenities as far as that's possible to do. So it's more of a two-way flow. So the balance between the security and openness is something which we try and manage. And I should point out that a retirement village is registered under the Retirement Villages Act and conforms with the description of that, whereas a gated community is often quite a different concept. It will be often a freehold development, is not necessarily registered under the Retirement Villages Act. It may well have covenants on the land so far as age restrictions and age minima are concerned, but it's not, we don't see it as a retirement village unless it's registered under the Act.
If I may just add a little bit to that answer. When talking about that intensification of the site, the other component is obviously with those central buildings which are housing the main care facilities and the key amenities. They're often sort of purposely centrally located on the middle of the site, so that the bulk and the height that goes with those buildings is able to be sort of centralised and kept away from the boundary where there's a greater risk of sort of interface issues with neighbouring residential character. And then the second sort of, I suppose, design technique that is often used as well is that often where there's a mix of townhouse units, for example, is that having townhouse units that front the street and with driveways that front the street as well helps maintain that continuity of residential a residential streetscape, I suppose. And so whilst they're still part of the retirement village, that street frontage is still outward facing. And I think that's also quite an important sort of design consideration.
Thank you.
Mr. Collins. Sorry, Malcolm, anything else? No. So, Mr. Collins, just to your paragraph 72, you talk about resource consent processes taking too long, that they're unnecessarily complex, etc. Was that a sort of a general comment reflecting your experience nationwide, or was that a comment particularly targeted at Selwyn district?
No, I think it's a comment of our experience nationwide.
Yeah,
we do know that, for example, in some parts of the country, the proposal to develop a retirement village creates a lot of angst from neighbours who perceive this vast palace going in with hundreds of car movements and the whole rest of it, which is far from the reality of the situation once they're built. So we feel that there is a misunderstanding in the wider public about how retirement villages work, and certainly that sometimes comes through in the consenting process.
Yeah, I understand that. No, that's helpful. Thank you. Right, Mr. Tanner.
sort of being alive to the sort of the overriding writing instructions, I haven't sort of prepared a separate executive summary or anything, but I'd obviously my evidence did have an executive summary from paragraph 12. I suppose that the key points from that executive summary, just to reinforce, is that, and as Mr. Collins has mentioned, the RVA and the retirement village operators have been putting a lot of resource into trying to get sort of continuity and consistency across districts in terms of how the plans provide for retirement villages. And I think probably the first sort of major work on that was probably in the Christchurch district plan around sort of 2015, where, I think from the sector's perspective, they provides good clarity in terms of what the expectations are. So I think that was sort of the driver for the submission by the RVA, is to sort of try and get that continuity and consistency for the consenting of retirement villages. And I suppose in this context, I mean, there's my analysis is there's a good level of agreement with the recommendations of the officer and the notified version in terms of how the plan does seek to provide for retirement living. I think the sort of the key areas where there's still some degree of difference is around the explicit recognition of retirement villages as a land use that does provide for that diversity of housing stock, which is a sort of a theme that comes through the MPS and is also sort of in the objectives of the plan, but it's never really articulated in terms of what that may actually translate to on the ground. So it's sort of getting some clarity in the provisions that retirement villages are a component of that. I think the other key thing that is outstanding, and I think it's sort of also reflected in the submissions and evidence of Kāinga Ora, is around the issue of amenity planned urban form, whether there should be an expectation of enhanced amenity in this plan, and with sort of variation 1 in the Housing Enabling Act sort of lurking large on the horizon. How does that all fit together? And then the other elements are around the assessment matters for retirement villages and getting them sort of fit for purpose. Another one was around the differentiating the buildings from a retirement village and the rule framework from the use aspect, which is what is done for other activities under this district plan. But for retirement villages, the current framework is the use and the buildings are bundled as one activity. And then issues around the plan providing better direction around notification matters, etc. So those are the points I sort of touch on in my evidence, and obviously I'm in your hands in terms of discussing those points further.
Great, thanks very much. Let's see if we have questions for you, Lindsay.
Thank you, Mr. Turner. Clear evidence on the most part for me, but if I can start you off with your para 53, where you support a redrafting of objective 05. With that redrafting, is there, seems to me to be no, if you like, no nod to the special characteristics or the environment in which a retirement village will be located, because you've got diverse residential environments in Selwyn. That one is, your proposed wording is very much around urban environments, built form, develop and change over time, MPSUD wording, if you like.
Yep.
But there is no nod to the special attributes of the area, whereas the 05 as proposed to be amended by the officer does talk about quality on-site residential amenity for residents and adjoining sites, whereas your proposal doesn't really talk about that at all in terms of that objective. Your reasons?
Yeah, I suppose there's a few bits to work through on that. In terms of that on-site amenity matter, firstly, it was my view, apologies, I'm sort of jumping between notified version in the 42A report.
Yeah.
At an objective level, I would have thought that on-site amenity is really captured by objective 1, where it talks about safe, convenient, pleasant, and healthy living environments. At an objective level, I think that does exactly, and I've said that in my evidence, I think is that sets a broad benchmark in terms of both streetscape and internally. That would then, at a policy level, you would flow down and you would articulate that further in terms of what your expectations are in terms of streetscape and on-site amenity. So my view was that there was a sort of quite a degree of double up between objective 5 and objective 1. And then in terms of the sort of the other sort of point about the fact that this is an objective that applies broadly across residential zones. I think the view would be is that there's still an expectation of change in all of those zones with this proposed plan. That's even in the large lot zone, it's not necessarily going to stay the way it is now, and obviously that's going to change further with the proposed rezoning, where a much larger part of the district would become that medium density residential area as well. So I suppose, in terms of drafting that revised objective, it was very much on the basis that the duplication issue between 1 and 5 was what I was addressing.
Okay. And then moving then to objective 3, your para 55, because objective 03 talks about, as notified, and the office is not proposing to change it, wide range of housing topologies and densities.
Yep.
Catering for population growth and changing demographics. But you actually want to carve out a specific objective purely relating to the elderly sector of the residential environment, the residential market.
Yes.
So it's not covered by changing demographics. Like, to me, when I look at changing demographics, so obviously in New Zealand and other places as well, people are getting older, the baby boomers are moving into that retirement age and so forth. So plans need to take into account that changing demographics. So I guess the question is, why do we need objective 03 as we've got it, and then a new objective specifically targeted to, if you like, the elderly sector of the residential market?
So I think firstly is that objective 3, it largely reflects the wording of the NPS UD and talks about changing demographics. But the plan doesn't really answer that question at objective or policy level as to what those potential changing demographics are and what the expectations are in terms of land use in the residential zones of the Selwyn district. I appreciate there's a need to have flexibility in that, but if we're just taking the language from the NPS and just repeating it down, and we don't actually answer that harder question as to what are we actually talking about, then the plan is a blunter instrument, I suppose. So I think there is value in acknowledging that there are particular types of residential land use developments that are specifically to address that changing demographic issue. I have suggested an alternative of incorporating it into objective 3 as an alternative. But I suppose in saying that is that as well as the Christchurch district plan, this was a point that was picked up, and it was acknowledged that it was a legitimate residential land use issue, and so I don't think it's so I think it's a case of that it's a consistent, some degree of consistency issue. But I think there was a point that was also made in the 42A report around it would overemphasize this certain sector. And I don't think the objective does that. I don't think it sort of says that, above and beyond other types of residential land use development that may be required, this one's preferred or favoured. it's a simple acknowledgement that this is a type of land use that addresses that overarching expectation in the NPS.
Yeah, I guess the comment that one could have about that is that objective 03 and talking about changing demographics really is targeted at the elderly sector, because the residential demands of the rest of the population are taken account of in a much more general way in terms of family housing or other housing which may be appropriate, whereas that changing demographics to me is really targeted at the fact that we have an older population coming through in much greater numbers.
Yeah, I suppose with that demographic issue as well, there's obviously things to think, the other things to think about around sort of income and housing affordability as well. And that I suspect that Kāinga Ora would have a view that's possibly at a different end of the spectrum than the RVA would around that demographic issue and the type of housing that they are providing.
Yeah.
So I think there is it covers a broad range of issues, but I think, and I appreciate that there are policies that talk about enabling retirement villages that flow on. But I think it was mainly around getting clarity around when we're talking about demographics, what are we actually talking about, and what is the housing expectations we're talking about.
But there certainly is a nod in the policy and the rule framework to retirement villages being a different form of residential land use than
correct
conventional. Okay, thank you. Moving into the policies, policy P12, which is supported residential accommodation in retirement villages.
Yes.
So I guess I'm a little bit unsure in terms of, are you unhappy with the officer's recommendations, or do you just don't feel that they go far enough? And this is explained in your new policy there, which is to me again is very much around the operational requirements rather than the context of the site. Do you have any comment on why P12 as recommended by the officer doesn't go far enough?
I suppose there are a number of issues with policy P12. So again, starting from the proposition that the association has been trying to get some degree of continuity, and a retirement village in Selwyn is no different to a retirement village in parts of Christchurch, etc. So getting consistency of policy. So this really does reflect what you're seeing in Christchurch. I think the other parts with P12 that would consider to be problematic was this reference to them being enabled where they're located within walking distance of essential facilities. So that's a big issue. I think that's a big issue. And it sort of creates a suggestion. I think I've seen the sort of the supplementary comments from the officer about that point. And Mr. Collins can probably talk about it a little bit more, but if the expectation is that a retirement village should be, within 800 metres of a centre, for example, because there'll be some of the residents that want to walk and they won't want to take a shuttle, that would be create a number of difficulties to finding suitable sites. And it's not a sort of a debate that I've seen in the sort of the retirement villages that I've been involved in. It's my experience that those residents that do move in that wanting to maintain their independence, their vehicle is their means of independence. It's not them walking a kilometre to the shop and back. And the other component of that is that the shuttle service that a lot of these operators provide is actually a social interaction as well. And so that was sort of a bit that I think was worth pausing on, because I sort of saw those supplementary comments.
Just on that, isn't there's a theme in the evidence that retirement villages are very much a residential activity and appropriate in a residential area. And I can accept that, but for other residential areas, if you are looking at a greenfield expansion on the edge of Rolleston here, for example, the same sort of criteria about access to local amenities, ideally within, the being good access to public transport, potentially being able to get to a local centre within close proximity without having to get in a car. Doesn't that also apply to retirement villages? Because there also is a theme that they do try and integrate in with the residential community in which they're located. So you want to comment on that?
If you're consenting a residential dwelling on in a residential zone in a greenfield part of Rolleston, for example, it's not my experience that you're going to be asked to consider how close you are to the local shops.
But isn't that a desirable thing in any community residential to have proximate access to facilities instead of having to get in your car all the time to go to them?
Well, that comes to the question as to how far out you zone your residential land, not the type of activity, not the type of residential activity that occurs there. Then,
so
I think what you're, because essentially, if the general residential area in Rolleston, if it extends, from where we are now, if it extends 5 kilometres that way, for argument's sake, a residential dwelling is still a permitted activity 5 kilometres from the centre.
But the appropriateness of that, whether residential land should be that far away, is taken into consideration when that land is actually zoned for that purpose as well.
Correct, and I'm only talking about a retirement village on a residentially zoned land, so it's doing the same primary land use as a standalone 3-bedroom dwelling that's next door. And you're not asking the expectations, you're not asking the 3-bedroom dwelling next door to the retirement village to have consideration to whether they can walk to the shops. But somehow there's sort of this expectation that the residents of the retirement village might want to walk to the shop, and therefore this location is not appropriate.
Yeah, so any residentially zoned site is fair game for a retirement village, regardless of whether it has access to local facilities.
Correct, and I've consented a number of retirement villages in Auckland, and it's simply not a matter of consideration.
Not a matter of consideration, or not something which is practically able to be achieved for many sites which are being looked at.
In terms of those where they're restricted discretionary, it's not a matter of discretion because it's a residential activity in a residential zone. And then I think if there was an expectation in this district that it should be a consideration, then I think the question that I would put back to the officers, I suppose, is what's an appropriate distance, and have they actually considered how far an elderly resident might be prepared to walk to some of these amenities? And if we're talking under 1 kilometre, then the ability to undertake, to find suitable sites for retirement villages will be significantly constrained, because you're looking for a large site within 1 kilometre of a centre.
Yeah, so that applies in obviously the bigger centres as well, but obviously less. And if you're looking at potentially West Mountain or Darfield or places like those, you might be able to achieve that because you've potentially got a bigger block of land, which is what you're looking at.
Potentially.
Okay.
And then I think, and just come back to the other components of policy. And it's a theme that sort of came through in other submissions as well. Is point 3, for example, where it talks about being of a scale and appearance that reflects the residential style and character of the locality. And I've sort of read the legal submissions on behalf of Kaingaora, which made a similar point, that there's a real risk with some of this drafting that the assessment is not against what's expected, but what exists at the moment. So it's not my understanding that the staff are proposing to change that drafting. So there's some fundamentals there with the policy that I don't agree with.
So it's planned urban form against, and if you like, a nod to existing character and amenity values which locate on the site.
Yeah, and that existing character one is where it becomes quite problematic. And you know, when we talk about residential character, what are we talking about? And I suspect, you know, you could get 5 different answers for the same community.
All within the ambit of creating well-functioning urban environments.
Mm.
Okay, thank you. One or two more. Ones we've answered. That one. Your para 95, your last sentence, also where peer review is engaged by council sometimes seeks to alter the design, etc., provide greater access to sunlight. Recommendations are based on achieving supposed urban design outcomes and not cognizant of the functional considerations that go into the design of the retirement village. I think I know what you mean there, but you're saying, in your view, a retirement village architect, when they do the master plan, you should trust them explicitly to achieve the urban design outcomes that a council or a community might want to achieve, rather than in terms of the internal amenity.
Internal amenity, yes.
And that goes right back to the fact that there should be much more permissive consenting regime for these things in terms of urban amenity. Isn't it quite wise also to have another urban design lens, potentially from a council, to look at something which is very often a large facility, you know, potentially 200 units or something like that, or more, or slightly less, but it is a significant built development. So isn't it actually also appropriate that somebody apart from the retirement village operator itself should actually be able to be involved or critique the outcomes in achieving a well-functioning internal urban environment? Isn't that also appropriate that the council retain some sort of say or input into those decisions, rather than leaving it to potentially the retirement village operator to promote?
I think if there was been identified through the analysis that there was an issue that needed to be resolved, then potentially, but I haven't seen any evidence that there is. And I think that's in my evidence where I drawn the decision in the Christchurch district plan, where from a plan preparation and what are the issues that need to be managed, has there been an identified need to get involved in that internal amenity issue? And in that situation, there wasn't any evidence that there was a need to do so. And I haven't seen in the analysis that's been undertaken in preparing this plan that there's an issue that requires resolution. I think that sort of the only real comment that I've seen is that there's a need to consider internal amenity in the same way as any other residential development. But I think my point still stands, is that I've had a very recent example where council's urban designers are wanting to get involved in the design of dementia courtyards and wanting more planting in there, etc. And as I've sort of experienced, is that there are real design sensitivities with those dementia courtyards in terms of what those residents are comfortable with. So it's all very well having someone else have a look over it, but have they actually got the expertise to provide advice on the actual relevant issues that are in play? If it's around the spacing of townhouses, etc., that might be one thing. But if we're dealing with there's a number of examples where you're dealing with the internal layout of assisted living suites, all these courtyards, etc., where standard urban design principles don't actually have a lot of applicability.
Isn't it also a fact in the past that, and I'm not suggesting in all cases, and as Commissioner Van Voorsthausen alluded to, we've both dealt with retirement villages at a consenting level before, but it isn't also urban design critique to deal with those very poor internal outcomes which could be. Now, I'm not suggesting that all retirement village operators are the same and they use good architects, but there could be circumstances where a poor design outcome for those residents, and they're a vulnerable sector of society, and we all recognise that, could potentially have the only aspect from a window looking out on a blank wall or something like that, which ideally you want to design out if you can. Isn't that an appropriate thing? Not dealing with the very good operators or the very good urban designers, but actually dealing with those that are, and that's reflected in the fact that a consenting regime is proposed through this plan for retirement villages.
I think if I might just have a tuppence worth there. I think it's important to understand that the business model around retirement villages basically means that every time a village is developed, it's looked at and improvements are made on the next iteration of the village. So the architects are well used to designing in improvements to what's ever gone before. The second thing, of course, is that the retirement village operator always owns the land and the buildings. So they never part company with the ownership as a residential developer might do in a conventional development. And because they always own it, they've got to make sure the development appeals to the next generation of residents. So they're always got to be thinking in the future proofing it so far as that's possible. So the next generation of residents' expectations are going to be met, because quite simply, if they're not, they won't be able to sell an occupation right agreement, won't be able to pay out the outgoing resident and all those sort of issues. So from our perspective, the industry is continually designing it, continually improving its design and approach to it. And I think the business model sort of will bake in, if you like, the good practices, which I think the council is looking for.
And just a further point, the example that you talked about in terms of sort of having a townhouse with a window facing a wall, for example, when you get to the restricted discretionary and the matters of discretion, I don't think that the matters of discretion actually allow the council to pick that point up anyway. The matters in this, in terms of appropriate on-site amenity, and that the council was talking about vehicle and pedestrian access, the location, orientation, and screening of outdoor living.
Well, that could apply as well.
Well, outdoor living versus a window facing a wall, I wouldn't.
Well, if you're looking at an apartment as opposed to a self-contained unit, and they only had one primary aspect, and for that is going to be looking at a retaining wall, for example, and that smaller area is there and they're only outdoor living, wouldn't that just generally apply in terms of good even design outcomes?
Yeah, I suppose again, there's a question around what is, when we talk about outdoor living space, is it a window or is it an actual space that they can go out onto? And I don't think that they are the same thing. But the commentary that I think you're sort of referring to is generally talking about, is the village well designed? And I understand the point you're making, but I don't think the matters of discretion are actually seeking to provide that broad review that you're suggesting might be necessary. And I think there's possibly a disconnect between the policy and the assessment matters in terms of what the expectations are.
Also talks about on-site amenity values in there. Matter 14.
Which one is that, sorry, sir?
Res Matter 14, design a small site development, comprehensive development and retirement village. Got on-site amenity values as a factor in there. Oh, sorry. Thank you.
Yeah, sorry, and I was working off the officer's version. So
yeah, no, I've got that. Well, I was going off the screen, and I did know that it actually had changed. So I take on board your point that there is a certain trust me, we know what we're doing, sort of, from the retirement village operators.
Yeah, and again, I just wanted to reiterate that in terms of that street interface and how the village fits within its locality as a whole, I totally accept that's an issue that needs to be resolved in any application. It's those internal things where that I'm not convinced there's a problem that requires resolution via this plan.
Okay. All right, thank you.
Thanks, Raymond.
In your paragraph 51, you talk about the NPSUD and how that's going to bring about change and diversity and with communities, people and future generations. And then you go on to say the change in the amenity and built form of residential communities is not recognised within Objective 05, which seeks to reinforce or lock in existing attributes of the local environment. Can you please explain to me what you mean by, and I'll go to my question. Please help me understand how by using the words reinforces positive aspects of the local environment, does it lock in existing attributes?
Because it's a case of they want essentially wanting development that relates to what is there at the present. Whereas there is an expectation that, and through the NPS, that there will be change in those residential environments.
But if the aspects are positive, why wouldn't you want to lock it in?
Well, I think if when you come to what's the policy 6 of the NPS, where it talks about there being a change in those residential environments, and that change not necessarily being an adverse effect, and the likes of what Variation 1 and the Enabling Housing Act is doing. It's my assessment of those matters that there is a move away to keeping rightly or wrongly, keeping things as they are, to we need to get more housing and intensification is required. And I think that's the point that I was trying to make there, is that trying to reinforce or keep positive local environment or the existing residential character are not what the higher order expectations are now.
Thank you. In your paragraph 55, which I will just go to now. Oh, I've gone past. Changing demographics. Now I've got to go back to my question, sorry. I presume you know of other district plan residential chapters that specify the nature of the demographic groups. Can you give me an example of a policy, for instance, where the nature of a demographic group is specified?
Where it's recognised that there's particular it's recognised as a demographic with a particular housing type need, for example.
Well, you've asked for the demographic, to specify the nature of the demographic groups.
Yes.
And I'm asking, can you give an example of a policy that does that?
Yes, I can. It's from the Christchurch District Plan in terms of its overarching residential objectives and policies, recognises that there's a need for housing for the elderly. I'm more than happy to provide that through the hearing administrator after this.
Yes, thank you.
Okay.
That's it from me. Thank you.
Malcolm. Tina, just one comment and then a couple of questions. I acknowledge the point you make about the differentiation in wording between character and amenity versus planned urban built form. And we're certainly aware of the need to give effect to the higher order statutory instruments, the NPSUD, and also we're aware of the enabling housing Supply Amendment Act and the direction that's pushing councils in. In fact, we'll be dealing with that in a more detailed manner next year when we come to cover variation one. So just acknowledge the point being made by yourselves and Ryman and Kaingaroa in that regard. Just a couple of questions. The first one just relates to that paragraph 51 that Commissioner Solomon was asking you about. Just when I look at the recommended wording, which recommends deleting the words responds to and reinforces positive aspects of the local environment, that would alleviate your concern, I imagine, about the lock-in issue?
I think in terms of that, that aspect of the objective, yes.
Yeah, okay. And then one other question, just in relation to policy 12 that you had quite a long discussion with Commissioner Dace about.
Yes.
Clause 1 of that policy.
Sorry, you're referring to the officer's version or the notice?
Let me just double check that, so I don't make the same mistake. Yeah, no, I'm referring to the officer's version and the notified version, because I'm talking about clause 1,
Yes,
which hasn't been recommended for change. And this is this whole proximity to shops and other facilities, etc. That clause 1 says where possible, located where possible. So if in the circumstances of a particular part of the Selwyn district, if it's not possible to do that, then I don't see what the problem is.
I suppose the policy implies it's desirable.
Yeah, and it may well be desirable, but if it's not possible, it's not possible, isn't it?
Well, yeah, that's fair. I suppose I would come back to that. There's presumption from the staff that it is desirable, and I don't think that's been demonstrated. And if I could just go to the matters, assessment matters. So assessment matter 13, location of comprehensive development and retirement village, takes out that qualifier. It simply is whether the development is located within walking distance of a centre zone, community facility, or an arterial road, etc. So it's not a case of, I think if the panel was of a mind to keep the policy as it is and the reference to where possible, my view would be is that the matter of discretion would need more, I suppose, colour to it to acknowledge that factors that might be relevant to considering whether it's desirable or appropriate or necessary for a village to be close to a centre.
Yeah, again, as putting on a decision maker's hat, I don't see an issue with Res Matter 13. I mean, it just, as a decision maker, I'd have to consider whether or not it is located within walkable distance. And then I'd look to the policy that says, well, where possible, it should be. But if the circumstances it wasn't possible, end of story. So, yeah, I'm not sharing your concern, I guess. All right. Okay, now that was all I wanted to ask you about, but thank you both very much for coming in, for the information you provided and for answering our questions. It's been very helpful.
Well, thank you, Commissioner. So from our perspective, we appreciate the opportunity to do it. I've got some material which I'll leave with the officers, some supporting material, Jones Lang, the reports and so forth. And we usually offer a tour of retirement villages to any officers or elected members of the council who'd like to take that up, because obviously when you get to see one close up and personal, you know, opinions may well change one way or another. So thank you for the opportunity.
Thank you very much. And our next submitter scheduled just before morning tea is House Movers section of the New Zealand Heavy Haulage Association, who I hope are coming in on Zoom. Is that? Yes. Now, good morning, Mr. Barner-Thompson. Can you hear us?
Excuse me. Sorry. Yes, I can. Yeah. Can you hear me?
Yeah, we can, coming in loud and clear, which is always a good start. So thank you very much for lodging your pre-circulated evidence, which we've read, so you don't need to read that out to us. You are, of course, very welcome to highlight key points for us, and then we'll see if we have any questions for you.
Lovely. Thank you very much. And listen, thank you for the opportunity to join you by Zoom. It's great to be able to take advantage of the technology, although it's not quite as good as being there in person. But anyway, hopefully we can still have a good dialogue and communication. So yeah, as you've said, I'm Jonathan Barner-Thompson. I'm the Chief Executive of the Heavy Haulage Association. We have a group within our association, which is House Movers, and we have a number of members that operate in the Selwyn area. I can think of 3 in particular that will operate there on a regular basis. So it's an area that we're familiar with. From our association's perspective, we've been making submissions to district plans around the country since 1998. So we've made quite a few submissions over the years to various district plans, but we're always conscious of the fact that each individual council area does have its own unique I guess requirements and intricacies, and we need to respond to the local conditions. So while we have a national approach, we always take a local view of how the relocation of buildings into the council area should be undertaken. I'd just like to draw your attention to the map in our submission that's on page 4. So this is the one that's coloured with bits of green, bits of yellow, grey and red. And so what this is an indication of is all the councils that we have submitted to since 1998. The ones in green are the ones that now have permitted activity status, usually because we've submitted to the district plan process. The ones in yellow are ones that are still going through a current submission process. And just on that, so working north to south, so that's Waikato District and New Plymouth, Central Hawke's Bay, Marlborough, Tasman, as well as Queenstown Lakes, as well as the combined West Coast plan. So they're all indicated that they're going permitted activity status for relocated buildings. So you'll see that quite a lot of the yellow, we're well through the hearings for a lot of those, and so they're all indicating permitted activity status. So from our perspective, quite a lot of the country will have that opportunity, if you like, to relocate a building with permitted activity status. You'll notice there's a couple of smaller red ones in there. So that's Stratford, and I think it's the urban area of Palmerston North, and that's simply because in the earlier days, getting information about which councils were proposing their district plans at various stages, we missed out. So that's simply all that's about, not because of a rejection of permitted activity status per se. So I think that's so in terms of our desire for Selwyn, we would also like permitted activity status, and I note that the planner's report has indicated that permitted activity status is the way that that they would like the direction to go for relocated buildings. And I notice in the 32AA assessment that they note that it's the removal of the resource consent from the process that they can see the advantage of, and that's what we would certainly endorse. In the plan, so in the marked up district plan, so our submission's actually been rejected in favour of Kāinga Ora, but in fact, as you can see from the detail of our submission, really, and my evidence that I put forward, really, we're happy to note that permitted activity is the way, or is the way that the planner sees that the council should move forward on this, and the hearings panel should move forward, and we're happy with that. You will also note that in my submission at 3.2, So over a period of time, so we have, in our engagement with councils around the country, we have developed a set of performance standards that quite often councils will accept. And this is really around the reinstatement process for a relocated house. In some areas, not saying that this is appropriate for Selwyn, so there have been examples where houses have been relocated within an appropriate time, and so that's where we've seen the timeframes. So that's why in our written submissions prior and today we're saying, listen, we would still like to see that. And I think that probably from your perspective, you might find that unusual. So here's an industry body saying that we want to be more regulated than what the planners report proposes. But I think that that's essentially so that so once a house is taken to site, that there is a timeline around which it is reinstated. So, however, if the hearings panel decides to accept the planner's report and we simply go for permitted activity status with no performance standards, then we would be accepting of that also. So the one request that we do make, and that's in 3.3, is that we still have the definition of relocated buildings to be retained in the district plan. And that's basically to acknowledge that relocated buildings coming into the area are recognised as if you like part of the building. So in the permitted activity, so where building is part of that permitted activity, that relocated buildings are also I guess specified, if you like, as a permitted activity status. So that's the one, like if our fallback position would be that that's what we would like to see. So so that's really the points that I wanted to raise to you and explain our position, and I'm happy to accept questions on that.
Great, thank you very much for that. Lindsay, any questions?
Yeah, just one, just in terms of that definition.
Yes.
Definitions are defined when they are used in other terms in the plan. So if there is relocated buildings become a permitted activity, is there still a necessity for a definition?
Well, that would be my argument, is that yes, we do, just to ensure that relocated buildings, so I guess there is no question that relocated building, sorry, let's go back a step. There's no question that as part of a building being permitted activity, so constructing a building,
Yeah.
that relocating a building is also a permitted activity.
Okay.
That
And
would be my argument, yeah.
And then you're entirely comfortable if there is a permitted activity that for this activity, that the criticisms that there have been over the years with relocating houses onto properties, that they get left up on 44-gallon drums or whatever until such time as there's enough finance or enough time to be able to do it. You're satisfied that there is enough levers in the Building Act to make sure that those undesirable outcomes don't occur?
I guess in the Building Act, the ultimate control is the fact that there will be a building consent issued for the foundations, normally
Yes.
timber pile foundations, and that will expire after a year, right? Or 2 years, depending on how you see it. Yep. So I guess that's the ultimate thing, isn't it? Is that the owner will have to, if it's not conducted within that time, then the owner will have to go back and get a new building consent, right?
Okay, thank you.
Yeah, I mean, we wouldn't like to see, I mean, the last thing we want to see is for buildings to be left not on permanent foundations. You know, for the normal process, and that's why we've included it in my submission, or my evidence here, is that our best preference is that houses are put onto permanent foundations within a short period of time, usually within days of arriving to site. So therefore we don't end up with houses that are sitting there in an unfinished state. So that's the usual most efficient business practice, both for the house transport and for the house owner.
Thank you.
Raymond?
No, thank you.
And Malcolm? And Ms. Barner-Thompson, no questions from me either. You've provided a very helpful summary this morning, and your written evidence, your paras 3.2 and 3.3 were very clear on what you're asking us to consider, and you've expanded on that today. So no further questions from me, but thank you very much for coming in and talking to us this morning.
Lovely. Thank you for the opportunity.
Thank you.
Cheers.
So we're now adjourned until 10:30 when we hear from Kāinga Ora. Right, good morning. We'll resume the hearing, and at this stage, we're hearing from Kāinga Ora, who are here. I was looking at the screen and there you are. Great, thank you. Well, I think certainly Mr. Jeffries has appeared before us before, and he very recently, and I think you have too, so you know the drill. Thanks very much for pre-circulating the submissions and the evidence. Don't need to read that out loud to us, but of course, each of you are very welcome to highlight key points, and then we'll see if we have questions for you.
Thank you, and thank you for the opportunity to address you this morning. So as you say, the legal submissions and the evidence have both been pre-circulated. The only thing that I really wanted to draw attention to is that consistent with its submissions throughout this process, Kāinga Ora's intention is to improve the plan, or to seek to improve the plan in a way that better allows for urban development, and in a way that is consistent with the national policy statements. And so that is the thrust of the submissions that have been made and the amendments that are suggested. We think that that the amendments that are suggested in Appendix 1 of Mr. Jeffries' evidence and in the submission that was made by Kāinga Ora do that, and more appropriately align with particularly the National Policy Statement on Urban Development. And I guess the other thing that is worth highlighting, although it doesn't necessarily have any weight as yet, but for all of us in the profession is a matter of interest at the moment, is the direction of travel that is being identified within the new legislation in terms of the Natural and Built Environments Act. And again, that does, in our view, reinforce particularly in relation to amenity and this issue of the status quo, and the status quo being used in the past to prevent development from occurring. And that so consistent with that, the changes, and consistent with the NPSUD, the changes that are suggested by Kāinga Ora are intended to allow for an assessment against a planned future state as opposed to the state of the environment currently. And that's, I think, where the dispute sits in some respects, is just what is the best way to do that, as between Kāinga Ora and Mr. Jeffries and the council planners. And so those are the only matters that I particularly wanted to draw to your attention. Mr. Jeffries has one amendment to make to his evidence, and so I'll ask him to just take you to that as well at the start of his presentation, if you don't have questions of me.
Great, thank you. I'll see if we have questions arising from the legal submissions, Lindsay. No questions from me either, but I'm not sure if you were here earlier where I acknowledged to the previous submitter just this issue of planned urban built form, and just acknowledging that point, and just letting you know that we're certainly aware of the requirements in the higher order instruments, the NPSUD and the Enabling Housing and Supply Act, and so we're well aware with the thrust of those provisions.
Thank you, sir.
But no questions or clarification. So, Mr. Jeffries.
Thank you.
Thank you. I'd just like to issue one correction. At paragraph 6.10 of my evidence, Kāinga Ora's requested amendment to Residential Policy 3 is incorrectly set out. The correct amendment to that policy is set out at paragraph 6.1 and in Appendix 1. So that was just an error of the track changes.
All right, thanks for that. And did you wish to highlight any key points, or are you happy to go to questions?
I'm happy to get into the questions. Thank you.
Great, thank you very much. Lindsay, any questions?
Thank you, Mr. Jeffries. Obviously, this is one of the issues which is front and centre to us at the moment. The relationship of the NPSUD, the residential zones, variation 1, which is we're not dealing with today, and the way in which amenity should or should not be carried forward through to the plan. You in your section beginning paragraph 6.9, and where you talk about residential policy 3.
Yep.
And you would have seen the officer's amendment, which is to basically take out the words maintain and enhance. Where we are with the legislation at the moment in the NPSUD, and your recommendation to make amendments to basically, in my view, take out any specific reference to character or amenity values of the area in which a site is located. We still have section 7, we still have maintain and enhance amenity values as being a matter in which we still have particular regard. Obviously, things may change in the future in terms of those high level matters. So is it not appropriate still to have some reference to both external and amenity values within that policy?
I think the point is about making these policies future focused. So it's not necessarily removing any consideration of amenity matters, but it is about setting out what those are rather than just tying it to the existing urban form. So that's the basis for the changes we're seeking. But yeah, it is to remove that wording, but it doesn't mean that that it's completely stripping out any consideration of quality outcomes.
Yeah, so it's more about achieving well-functioning urban environments as opposed to referencing any existing matters in the existing environment that need to be taken into account, forgetting about any qualifying matters or heritage or anything like that. But it really is, if you've got bulk and location provisions which apply for a certain outcome, and if they're met, then there should be no necessary reference to look at the character of the existing environment.
I wouldn't quite say that it's fully defined by the bulk and location standards. The objectives and policies should provide, they should set out outcomes that go beyond that. And I think this amended set of the amended objectives and policies for the residential and for the individual zones does that.
So, sorry, in terms of built form, for example,
Yeah.
got bulk and location standards which apply.
Yeah.
So I don't quite follow your rationale for your statement about I'm sorry, I've just lost my train of thought there. So the bulk and location standards will actually set, if you like, some sort of baseline in terms of the character of an existing planned urban form. Is there more to it than that, which you should feel it should be referenced in policy P3?
I don't think there needs to be additional changes to what's recommended by Kāinga Ora. But I'm saying the package of objectives and policies, and including the individual zones, the outcomes they set out, do enable consideration of things that go beyond the permitted standards or the rule requirements. So I think it's just a subtle difference there.
Okay. Okay, thank you. And in terms of streetscape amenity, in your, well, it's actually titled paragraph 7, but it's under 619. We reference achieve outcomes in objective 5 as amended. So you're not proposing any so you're happy with the amendments to objective 5?
Yes, that's the recommended.
The 42A recommended amendments.
Yes, those follow what they follow what was sought in the Kāinga Ora submission.
Yeah. But we've just heard from the Retirement Villages Association that had some issues with Objective 5 in relation to on-site residential amenity. They had the view that on-site residential amenity should not be a criteria for them to in terms of a retirement village. So you're saying for general residential, any residential activity, on-site amenity is a matter which the council, within its limitations, should have some recognition of in its decision making.
Yes, I believe so. And I think it's important to separate that out from adjoining site amenity. And that's what the Kaingoa amendments are seeking, so that it's clear which one is being addressed.
Okay, right, thank you. Moving next to your comments on notification and the rules, etc. So if a proposal, was my understanding, if a proposal needs a resource consent, but it applies with bulk and location provisions, there should be, in your view, no requirement for notification over and above special circumstances. Is that your view?
Yes.
Okay. Do you feel that the rules that are in place are sufficient to be able to assure that any other external factors are covered?
Well, I think there's a balance to be reached, and I think precluding notification where the height and setbacks are complied with is appropriate for those other factors. I think that achieves an appropriate balance of enabling notification in the circumstances where it's warranted, and limiting it where the breach is limited to other factors that are probably more about on-site amenity.
Okay. Because there is school of thought that there may not be need for any non-notification clauses because the Act already provides the circumstances where they should be applied.
Well, I don't agree that Act on its own provides enough certainty or enough direction around that.
So in this particular circumstance, a non-notification clause is entirely appropriate where otherwise you meet the various other standards which apply. There should be no specific reference to, or there should be a specific reference that these applications where they are required should not be subject to limited or public notification.
That's correct, and that's still retaining the ability to consider notification when there is a breach of height or setbacks.
Yeah. Moving from that to your comments about fencing, you would have seen the officers have made a recommendation in terms of secondary frontages on corner lots that they can go much higher. Do you not feel in a conventional residential environment that a high fence on the front boundary has effects on the streetscape? I know you talk about permeability, but if you're using, say, a front yard as your primary area of open space because it has good aspect, it's pointed north, or there may be change in elevation, probably not so much in Selwyn, but certainly in other parts of the country. But if there is a change in elevation, but that a high fence could lead to a poor outcome in terms of the streetscape. And the reason I ask that is if you have a high fence, you'll often want to put things in behind it, like storage, or if that is your main area of amenity, you might choose to put things in there which, such as a small shed. I've seen those, and this is your primary area of open space. It's on the street frontage. You want to put a small shed in that area. Is that a desirable streetscape outcome in a general residential area if you have a high fence? A low fence, it's much more, you have much more surveillance. You have much more viewing into that area than you would if there was a high fence.
Yeah, I agree that fences can impact on streetscape. And yeah, that there is principles of urban design about facing the street, but there is also somewhat of a trade-off with privacy and with being able to use safety for children as well. So the changes sought are seeking a balance here, and the permeability in the requested amendment does ensure that there's some level of passive surveillance of the street is still possible, while still enabling those privacy and safety benefits for the residents. So yeah, I think there is urban design issues to address, but they're somewhat in conflict with privacy and safety, and there's a balance to be reached that I think the amendments do.
But presumably where these areas are going to be created are part of a comprehensive development where you look, if you're a residential house builder, you're wanting to build 100 houses on a site, you design that to be able to take into account both the street frontage, but also the levels of residential amenity, the internal residential amenity, which would apply to each individual site. So a high fence would potentially affect the streetscape, regardless of whether it's permeable or not. It would, whereas having a much lower fence would actually be a better urban design outcome. Well, perhaps repeating what we just discussed anyway, but isn't there an opportunity with a comprehensive redevelopment to be able to design out those particular issues or problems?
Well, not in every circumstance, and I mean this has come about through Kaingora's experience in development. A lot of these urban design principles don't always hold in every situation. There's difficult trade-offs to be made in design, and that's been Kaingora's experience, that they've needed more flexibility with fences, given the needs of their residents. But
that'd be the exception rather than the rule, though, wouldn't they? Because if you look at open space around a residential property, don't you want to have, ideally, an individual occupier might want to have privacy, somewhere where they can hang their washing out if they choose to do. So wouldn't, by having a 2 metre high fence or a 1.8 metre high fence as a permitted activity, it doesn't send the wrong signals about where the private open space for an individual property should be. Well,
it is enabling more flexibility, and yeah, in my view, that permeability provides for some of those benefits of surveillance. But yeah, I mean, there's difficult trade-offs in design, and the principles that hold in most circumstances, or the good rules of thumb of design, don't always give the best outcome in every circumstance, and that has been Kaingora's experience in designing these properties.
So can you give us a specific example where this is applied and what it looks like in terms of KO properties?
I don't have an example to speak to. I just understand from discussions with Kaingora that they've run into problems with these rules elsewhere in the country, where there's been highly restrictive rules around fencing, and their design, which their designs always take into account streetscape and seek to address those things, but they've found them a bit too restrictive when it comes to achieving privacy and safety for the residents.
So wouldn't it be more appropriate to have a case-by-case resource consents for those circumstances where such a scenario would apply?
Well, I mean, that imposes quite a high cost on what is a relatively small part of the development.
But if you're trying to achieve a well-functioning urban environment, isn't it appropriate that a degree of assessment is required about whether that is appropriate, or whether there is alternatives, or whether or not there's a different design measure which can achieve the same outcome, or whether there could be a rejig which would achieve better outdoor space, better streetscape than being able to, as a right, put up a 2 metre high fence on a primary frontage?
It is 1.8 meters that they're seeking.
Yeah, 1.8, yes.
Yeah. Well, I just don't think that the costs of a resource consent process would be met by the benefits in this circumstance.
But
I
if
think
it's
it would
gonna,
be better to have it as a permitted.
if it's gonna potentially need resource consent as a comprehensive residential development anyway. If you look at other plans, if you multi-unit development, it often triggers a resource consent anyway under the current provisions, forgetting about MBA and forgetting about or areas outside of medium density.
Well, I think we're getting outside the standard that we're discussing, or the rule requirement we're discussing. In
Yeah, but we're talking about general residential as we have here at the moment. So
yeah,
in
but
terms of the site coverage, the other bulk and location factors that apply to a site coverage, setbacks, so forth. I don't want to linger on the point of the high fence. It's just that, but it is just it is a factor which in some circumstances could lead to perverse outcomes when there may be alternatives and might need to be assessed on a case by case basis.
Well, yeah, it is my view that it's appropriate as a permitted
All right,
standard.
well,
Yeah.
we'll leave that there. Can I talk about height to boundaries? You have something of a problem with the Selwyn height to boundary controls relating to the orientation of the building itself. And there it is in other plans it is used. Wellington, for example, do use that, and it's in a residential area. They have a height to boundary control which does relate to the orientation of the building to the sun.
Yeah,
because that provides better outcomes. So I recognise that Selwyn is perhaps a little bit different from other councils which have a definite measure instead of one which relates to a 360-degree orientation factor. But do you just see that you just need a blanket 2.5 or 2, and forgetting about MDRS, but a blanket one such as there is in the hut, for example, or out of residential on Wellington? You feel that is much more appropriate than having something which is, from what I understand from the 42A report, is a height to boundary control which has been used in their view relatively successfully in the Selwyn context.
Yeah, these rules have been used in a number of plans.
Yeah.
My point is that they are complex rules. They're very difficult to understand if you are not familiar with them. That the way the Selwyn one is expressed, that there's probably people are used to it and have built up knowledge, but if you'd never seen that rule, it'd be very difficult to interpret.
But if you're getting a good architect and you've got a flat site and you know where the north point is, you can work it out relatively easily.
Yeah, they're not impossible to interpret, but in my view, the complexity that they introduce is not worth the benefits. I think there is benefits in having a simple height in relation to boundary. It's simple to interpret. There's less likely to be disputes on the interpretation, and another factor is it enables standardized construction. So yeah, I think, and also the way the height in relation to boundary in the proposed plan has very restrictive angles, more restrictive than 45 degrees, which in my view is inappropriately restrictive to achieve what it needs to in enabling light to the site.
Yeah, but isn't it also a factor that the south side recession plane breaches are more significant in terms of the effect beyond the site than a north side recession plane breach? So if you have a standard one size fits all, regardless of the orientation of the building, there are areas of the site or the areas of the building which are going to produce shading on adjoining properties which are more significant because they are to the south side.
Yeah, that's true that the sun comes from the north, and yeah, shading effects are worse from the south, but I don't think it's a significant enough difference to warrant the complexity of the rule and everything that comes with that, and the difficulty in standardizing construction, difficulty interpretation. And I think a recession plane of at least 45 degrees, I think is sufficient even on the south side to protect those things. It's getting very restrictive, getting less than that. And it really starts eating into the built envelope.
Yeah, it also depends on where you take the 45 degrees from as well.
Yes.
Like some have 2 meters, some have 2.5, 45, some have 2.1 in Kapiti, I think, for some reason. They have 45 degrees, but they're also in more denser existing environments. There is also this, and thinking about Wellington, for example, in a residential areas, there is if you've got a street frontage, you can have a much lower recession pane breach because the shading doesn't, it falls on the public space as opposed to an adjoining property. So, you know, to some and in some contexts, there is merit in having a graduated or recession pane provision that applies. That is the view of certainly some councils historically anyway.
Yeah, I understand the rationale for these rules. It's just my view that they don't, those benefits don't exceed the complexity of those rules.
Okay. All right, we'll leave that one for now. I actually don't have any other questions, but thank you, Mr. Jeffrey.
Yes, I do have a couple of questions. I'm going to ask this again, but in a different way. Are you proposing focus of the residential zone? I'm talking about RES Z01 be on development and not on safe, convenient, pleasant and healthy living environments.
So we're seeking a changing to the wording. That is, so the wording that we're seeking here is development is in keeping with the planned urban form of the residential zone. So that amended wording to the objective would form a connection to the individual zones, which also set out the outcomes sought. So that's where it can articulate what's being sought for the zone. Also, this is in the context of the full set of objectives, because there would also be objective 5, which built form provides quality on-site residential amenity for residents and adjoining sites and achieves attractive and safe streets and public open spaces. So there is, within the set of objectives and policies, there is still the ability retained to consider those things, but it's about changing this one to link it to the future built form, which is then articulated in the individual zones.
I think you've answered my question, but so thank you. So my next one is, do you consider that, and despite the definition of in keeping, by using the words in keeping with planned urban form, it may lock in this point in time and thwart future progress?
No, I don't quite agree with that. It's about, as I've said, about creating a link to the future outcome that is set out in those zones. So in the general residential zone, the large lot zone, that each of those zones will have an outcome, and that's future focused. So it's not, I don't think, locking it in.
Okay, answers that question. And my last one is, aside from development, objectives, information's been put before us about objectives needing to be aspirational. With that in mind, aside from development, which residents would the objective be aspirational for if we went with the Kāinga objective?
Sorry, I don't quite understand the question.
Aside from development, if we were to accept Kāinga Ora's objective 01, aside from development, which residents would the objective be aspirational for?
That's not the wording used, but if you're seeking if you're wanting to know who benefits from these amended provisions,
I want to know who would be inspired, be who would that objective be aspirational for? Given that objectives are meant to be aspirational, aside from development.
Well, objectives are meant to set out an outcome. So, and this is referencing the outcomes set out in the other zones. So it's creating a link to other objectives. But I believe that set of amended objectives and policies, I believe, reaches a good balance of enabling future development. So that's that which would benefit future residents, but it also balances that with amenity outcomes for current residents.
Thank you.
Malcolm? Secretary, I've just got three matters I'd like to ask you about. The first one is at your para 6.1. And it's Reso 1, your recommended wording to us. You've just said in answer to a question from Commissioner Solomon that objectives are outcomes, or they should be outcome focused, which obviously is correct. And so I'm yet to be persuaded why your recommended wording to us, where you're seeking to delete the outcome that was specified in the notified objective, which is for safe, convenient, pleasant and healthy living environments that meet the needs and preferences of the community, why we should delete that objective which specifies a pretty desirable outcome and replace it with your wording, which doesn't have any kind of particular outcome at all.
Well,
So I thought I'd give you an opportunity to try and persuade us on that.
What's that, sir?
So I'm giving you an opportunity to try and persuade me why your wording is a better outcome than the notified version.
Well, it doesn't set an outcome out on its own. It links to the outcomes that are set out elsewhere for the zones. And I think that's appropriate given that these are going to apply to a number of zones that are different. So it lets that those differences, it creates a link to the differences set out in those zone objectives. But also, if you look at the full set of objectives for the residential, we also have, among others, we've got objective 5, which sets out in a more specific way the outcomes regarding on-site residential amenity for residents and adjoining sites and safe streets.
Yep. So in answer to that, my question, I think you said early on in your answer that these res objectives apply across all the residential zones. So which of the residential zones would it be inappropriate to have a safe, convenient, pleasant and healthy living environment that meets the needs and preferences of the community?
Well, I think that the issue with these wording is they are quite subjective terms, and it's difficult. It would be difficult to use this to interpret what outcome is sought. But I mean, it's hard to disagree. You're right that they're all nice things to have, but as a district plan objective, I think that they are too subjective.
So which words are subjective in your mind? Is safe subjective? Not subjective, is it? A safe community is not objective, is it?
Well, perhaps safe isn't. Convenient, pleasant, I think, are subjective. I'm not sure what that would mean in a planning context specifically.
All right. So 2 more questions. Your para 9.10. Now you're asking us, or you're recommending that these provisions listed there be deleted and comprehensively reviewed. Now, as an experienced planning witness, you'd understand it's difficult for us to accept your recommendation in the absence of precise wording. We just can't make stuff up, can we? We need evidence to base it on.
Sorry, what paragraph we're talking about? The height in relation to boundary?
No, your para 9.10.
9.10.
You recommend that those provisions are, reading out your words, be deleted and comprehensively reviewed to introduce a new set of rules.
Yes, so we haven't provided specific wording. We've provided a recommendation on what the new rule should achieve. But yeah, it's about making a more simple rule. I think it could be you could have a similar rule with the same starting points for the height in relation to boundary. With the 45-degree angle, and there is plenty of examples of those around the country that could be used.
Yeah, I guess the point I'm making to you is that as a planning witness, you'd understand we can't do that unless someone's provided some precise wording for us to consider. So I don't want you to get your hopes up in this regard. Okay. And your para 913, just the fourth line from the bottom. Are you saying, sorry, have you got that? Para 913,
Yeah.
fourth line from the bottom of that paragraph. Is it your evidence that shared access ways should not be safe and attractive?
No. It's that objective does not apply to them because they're not streets. I disagree that those elements and those principles of design that you apply to the street and the streetscape should apply to a driveway. They are a different thing. So it's not saying that they shouldn't be safe or attractive. It's just they shouldn't have the same design treatment that you would give to a street.
All right, thanks very much. No further questions from me.
So just if I might just two matters that I wanted to pick up in relation to that. I've listened to your discussion and indeed Commissioner Dace's discussion around Res 01 in terms of that objective. And I think what I would add to that is the subjective part of that, of course, I think is that meets the needs and preferences of the community. And that is the sort of objective that has often in the past been used to read down the balance of the objectives and policies if the needs and preferences of an existing community are not met. And I think that's the concern that Kāinga Ora has expressed. It's the concern that's been expressed in terms of some of the material that's come through the NPSUD, and it's the concern that's been expressed in relation to reform, is that as communities, sorry, existing communities, let me take that one step back, that our urban environments will not change if our existing communities continue to want what they currently have. And that is the difficulty that Kāinga Ora is trying to resolve here in that change in wording. I suspect, and you know, that Kāinga Ora has no difficulty with safe, convenient and pleasant and healthy living environments. That's what the outcomes in those other zone provisions provide for. But it is that second part in terms of meeting the needs and preferences of the community that is, as I say, sometimes read down to mean just the existing community. The other matter that I just wanted
Sorry,
to...
can I just ask a question on that one? You'll be aware that the objectives need to be read as a whole. So,
Yes.
you know, when we, in terms of that comment on objective 1, we then need to look at objective 3, don't we? Which is about providing choice for the community to cater for population growth and changing demographics. So that would countervail that argument, wouldn't it?
Absolutely, but it's the argument that we find ourselves having with councils up and down the country, I guess. And if we can provide a planning regime that eliminates some of that argument and having to go, but yes, but. Then that's helpful to us in terms of, you know, good plan making.
Yep, sorry, and you wanted to make another point?
Just in relation to the height boundary rule, just in relation to the question of scope, I appreciate what you're saying that Kāinga Ora hasn't provided a specific rule. I don't think that precludes you in terms of a scope argument from making a change if there is evidence to suggest that the existing rule is not the most appropriate. I guess that what you're saying is that you haven't got something in front of you that you can necessarily do, but that is, I mean, certainly there are, the scope is provided by the submission to amend that rule, irrespective of whether a specific amendment has been provided to you. Appreciate that you might consider that's not work that you are required to do, but I would just want to make the point that scope is available.
Sure, but just my general approach to this in any kind of plan hearing is that if someone just says we don't like that rule, please put another, you know, change it, rewrite it. My general response as well, if you haven't done the work to tell us what you think it should be, don't hold your hopes up that we're going to do it for you.
I appreciate that, sir, and I think we've all heard that message at various plan hearings over the years as well. Yeah. Thank you.
Great, thank you very much. So our next submitter is Hughes Developments Limited. Morning and welcome. I mean, you've appeared for us very recently, so I don't think I need to repeat the drill, but I will for the benefit of anyone who might be watching the live stream. Thank you very much for the submission and the evidence you presented in support of that. You don't need to read the evidence out to us because we've read it, but you're very welcome to highlight key points, and then we'll see if we have questions for you.
Hi everyone. Yes, I was here earlier in the week, so I won't introduce myself other than to say I'm Alice Burnett and prepared evidence on behalf of Hughes Developments. My evidence addresses 5 submission points: residential rule 9, the definition of small site development, large lot residential zone rule 6, general residential zone rule requirement 9, and low density residential zone rule requirement 11. Yeah, I think my evidence is quite concise, so I'll ask offer questions.
Great, thank you very much for that. Lindsay, any questions?
Thank you. No, I don't have a lot. I guess I'm just a little bit confused about how we've got to this necessity for 351 square meters for small site developments. It's an odd number to actually have in a permitted activity rule. So can you just sort of flow me through the thinking about where you got to for the 351?
Yep, I appreciate the randomness in terms of the evidence. So for the Hughes development submission, there were 2 submission points: one on the subdivision to facilitate small site development and the corresponding definition, and then the rule for comprehensive development. At the time of notification there, and I mentioned this in the subdivision hearing earlier in the week, that there was a gap, if you want to say, in terms of those 2 and what was the minimum and maximum net site area. So our original relief was to seek to essentially merge the 2, so there wasn't a gap. As a result of the 42A report, the comprehensive rule requirement for the subdivision was amended to basically say that there's no minimum lot size. So yes, that, you know, in terms of scope, we've got 351 because that was our original submission.
Do you think that 351 is the appropriate measure for dealing with this issue?
Are you suggesting that there could be a round number, for example, 350?
Well, you don't often see a number with like that for a either permitted activity condition or something which you can hang on in terms of what I wouldn't call an arbitrary development standard, but a particular development standard which would apply.
Yeah, in terms of scope, I'm not sure what leniency we've got in terms of changing that number.
I think we'll think about scope, obviously, and things have to be within scope, but we also need something which is pragmatic and usable as well, which is going to endure.
Yeah, I mean, I'm more than happy to change that to 350.
Now, you obviously heard there's a little bit of similarity in terms of my questioning Mr. Jeffries in terms of fences and public open spaces and front yard setbacks, etc.
Yes.
Now I see you make reasonable amount of discussion in your evidence in relation to the front yard setback and the fact that you don't have front opening garage doors as well, and you could get a large SUV within 5 meters and so forth. Other plans certainly have a desirability that the larger vehicles that there are which could park in a space don't poke out into the, but there are certainly larger vehicles which are commonly available which in between the 5 and the 5.5 meters. So it's is it one of those things that is incredibly important in terms of urban design, or is that extra half a metre? So it gives you so much more flexibility in terms of being able to provide a front yard setback.
So in relation to the small site development,
Yeah.
which I think is what you're talking about.
Yeah. In your conclusion, you've got 5 things that you want. Garages shall be set back a minimum of 5 metres from that boundary.
Yes, so one of the rationale behind that is because there's other rules in the proposed district plan which are now enable that garage garage door to road setback to be 5 metres. So one of the reasons for it is for consistency. In terms of looking at cross sections for roads, when you look at where the berms are in the footpaths or shared cycle paths, for example, areas for tree pits, it's quite often that the footpath is not actually on the side closest to the residential property. A lot of the reasons for that is for safety of those users of the footpath or shared path from backing vehicles, etc. So there, if someone does have a larger vehicle, there is a possibility that there would be some overhang allowed that wouldn't intercept someone on that footpath. However, if someone did have a larger vehicle, there is also the opportunity to park on the road in most situations.
Yeah, but if you're looking at the new environment that we're facing in terms of residential development,
yep,
we actually look at the design of the roadways themselves and the requirements for berms. There's some of the view that berms are a wasted space. They, they provide on-site amenity, but in more densely populated areas or intensely developed areas, the berms are dispensed with. So that argument wouldn't necessarily apply then.
I think there's still a role for having berms in areas because they do contribute to the streetscape of an environment. I guess the other reason for reducing the garage setback is on those smaller lots, for example, that half a metre will quite be more useful in an outdoor living space if, for example, it's on the non-road side of the section, usually space that's within the residential property, within the residential unit and the road on, if you're on the northern side of a road, for example, those lots don't usually use those spaces very well, and it can sometimes be used or considered wasted space. So that extra half a metre will contribute to someone's internal site amenity.
Okay. And the last one on fencing, and I had quite a discussion with Mr. Jeffries about fencing, but your points are slightly different. I think in terms of those internal boundaries. So you're wanting 1.8 metres all the way along that internal boundary right up to the frontage.
Yes.
Rather than having graduated set down and then you can go to 1.8.
Yeah, so
that.
Through my evidence in driving around the district, there are examples where there was a combination of a 1.8 metre fence that dropped down to 1.2 within short distance of the road. In majority of those situations, they were landscaped to the point that they were probably higher than 1.8 metres. So I don't think that would provide as much of a benefit. I think a 1.8 metre fence would achieve the desired outcome from a privacy perspective.
Okay. But also if you have that 1.8 metres which goes all the way up to the frontage of the property, that will produce quite a different streetscape in terms of the openness. And forgetting about whether it's landscaped or not, but you've got a hard structure which is at 1.8 all the way up to the street boundary with what you're proposing here. And you have lots, generally fairly intensively developed lots, which you're potentially looking at the future in terms of 300 square metre lots, for example, where you have a much narrower frontage per lot. So therefore the part that is perpendicular to that frontage, which is that side boundary, is much more obvious because you don't have the separation in between the boundaries that you would with larger lots.
Yes, in relation to the smaller site development, yes, that's probably a fair statement to make. In terms of the large lot residential zone rules, in terms of your frontage width and your minimum net site area and minimum average, that's probably not the case so much, being that they're 3,000 square meters or 5,000 square.
Yeah, I wasn't necessarily referring to large lot.
Yeah.
Yeah. It is, yes, okay. All right, thank you. I've got no further questions.
Malcolm?
Yeah, I just want to explore the small site development with the 5 meters versus 5.5 meters. You people of huge development are doing a lot of development. You've done quite a lot of small lot in places as well. Just interesting to note, my observation has been that when I drive through these areas, I see the large vehicle sitting outside the garage because there's no room for it in the garage. Because the garage is full of the clutter of life, or they've turned it into a lounge by carpeting it because it's a small lot and they want extra room. And so the vehicles don't go in the garage, they sit out the front. That sort of necessitates the necessity to have a bit more of a gap between there and the front. And then I combine that with your 1.8 fence setback. I think if I'm sitting in that vehicle and I'm trying to get out the drive, I can't see who's coming down the footpath. I mean, you have made a valid point that a lot of that cut down has been landscaped in some cases. But I'm very concerned about SITTED, and I'm also very concerned about the practicalities of people getting in and out of their sections.
The relief sought for the 1.8 meter internal fence is for large lot residential.
That's for large.
Yes.
Also,
Okay, sorry. Nothing more.
not to my knowledge, no. Mhm. Yep. No, I guess not. I guess for a security reason, I'm not sure whether someone would put their e-bikes, which I understand are quite expensive, on the back of their car for a long period of time. Oh, sorry, I see what you mean. Right. Yes, they can be. Yeah, I think that goes back to my point that I made before about the cross sections of a road. It's quite common that there won't be a footpath right on that residential boundary, and therefore there may be if there is some overhang, it may not impede the pedestrian or cycle shared path users. Yeah, so so I think that's what I'm trying to make the point is that the shared path or footpath is usually on the road side of a residential property, and there's usually a grass berm or something in the middle between the two, where you can have tree pits and things like that.
Okay, well, thanks very much. No further questions from me, but thanks very much for coming in. And our last submitter of the day is Kiwi Rail. Is Kiwi Rail there?
Sir, can
Good
you
morning,
hear
Kiwi
us?
Rail. Can you hear us?
Yes, we can hear you. Can you hear us?
Sure can. Thank you very much. I think through our hearings administrator, we conveyed to you that having read the pre-circulated material, we had no questions for you, but you said you indicated a wish to appear before us anyway. So
Yes,
over to you.
And thank you for confirming that, sir. And if that is the case, we're really here just to confirm if you didn't have any questions of in relation to the legal submissions or the evidence. We don't plan to use the panel's time to go through everything. If you've read it all and you understand it, but if there were any particular concerns about the relief that KeyRail is seeking, happy to address any of those concerns now, sir.
Thank you very much for that. Well, from my perspective, having read the legal submissions, I don't have any further questions because the legal submissions really just repeated the planning evidence. So, but I'll see if we have any questions for you. Any questions, KeyRail, Lindsay, Malcolm? No, it appears we have no questions for you. The evidence was clear and we understand what you're asking us to do. So thank you very much.
Okay, thank you, sir. We'll leave it there then.
Great, thank you.
Great, thank you, commissioners.
All right, so that brings us to the end of the today's hearing of submissions. Thank you very much, everyone.